The end of the Second World War in 1945 marked not only the physical collapse of Nazi Germany, but also the moral reckoning of an entire generation that had witnessed destruction on a scale previously unimaginable. As Allied forces advanced into Germany, evidence of atrocities poured forth. Concentration camps liberated by soldiers revealed the industrialized extermination of millions of Jews, Roma, and other persecuted peoples. The world demanded justice, not vengeance, but a lawful process that could demonstrate to history that even in the aftermath of barbarity, civilization would respond with law. From this moral impulse grew the idea of the International Military Tribunal, commonly known as the Nuremberg Trials. The decision to hold such trials was not inevitable. After the First World War, similar calls for accountability had ended in failure. The victors of 1918 had tried to indict Kaiser Wilhelm II, but political compromises and the absence of legal precedent rendered the effort meaningless. By contrast, in 1945, the Allies, primarily the United States, the Soviet Union, the United Kingdom, and France, understood that the sheer magnitude of Nazi crimes demanded a different response. They envisioned a tribunal that would define and punish crimes against peace, war crimes, and, for the first time, crimes against humanity.
The city of Nuremberg was chosen for symbolic and practical reasons. Once a ceremonial heart of the Third Reich, where Nazi rallies had glorified totalitarian power, Nuremberg now served as the stage for dismantling that same ideology. Its courthouse and adjacent prison remained largely intact, providing a suitable venue for an unprecedented trial. The legal foundation was laid in the London Charter of August 8, 1945, which set forth the structure of the tribunal, the composition of judges, and the categories of indictable offenses. Each of the four Allied powers appointed one judge and one alternate. Together, they formed the tribunal that would judge the highest surviving Nazi leaders. The defendants included names that had once dominated Europe: Hermann Göring, Joachim von Ribbentrop, Wilhelm Keitel, Alfred Jodl, Rudolf Hess, and others, 24 men in total. They were accused of conspiracy, crimes against peace, war crimes, and crimes against humanity. For the prosecution, it was essential not only to prove individual guilt, but also to establish the principle that following orders was no defense when the orders themselves violated fundamental human morality.
Preparations for the trial were monumental. Thousands of documents had to be collected, translated, and authenticated. The Allies gathered footage from concentration camps, seized Nazi archives, and interrogated witnesses. For the first time, film evidence would be used in a court of law to confront the accused with the reality of their deeds. The prosecution teams came from different legal traditions: Anglo-American adversarial systems, continental European inquisitorial procedures, and Soviet legal frameworks, yet they managed to create a hybrid model that balanced fairness with efficiency. When the trials opened on November 20, 1945, in courtroom 600 of the Nuremberg Palace of Justice, the world listened. Radio broadcasts carried the proceedings across continents. Inside the courtroom sat four judges: Lord Geoffrey Lawrence from Britain as presiding judge, Francis Biddle from the United States, Henri Donadieu de Vabes from France, and Iona Nikitchenko from the Soviet Union. The chief prosecutors were Robert H. Jackson, U.S., Hartley Shawcross, UK, François de Menthon from France, and Roman Rudenko from the USSR. Jackson, in his opening statement, declared that the wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored. His words captured the gravity of the moment.
The defendants sat behind glass, listening through headphones to translations in English, German, Russian, and French, the first large-scale use of simultaneous interpretation technology in a courtroom. Some appeared defiant, others resigned or visibly shaken. Goering, the highest-ranking surviving Nazi official, tried to dominate the proceedings with arrogance and sharp intellect, but the overwhelming evidence of guilt steadily eroded any aura of authority he attempted to project. The charges themselves were revolutionary in legal history. Crimes against peace referred to the planning and waging of wars of aggression. War crimes covered violations of the laws and customs of war, including murder and mistreatment of prisoners and civilians. This last category in particular gave the tribunal its enduring moral significance. Never before had an international court articulated that individuals, not just states, could be held criminally responsible for atrocities committed under government authority.
The trial faced criticism from the outset. Some accused the Allies of hypocrisy, arguing that bombing civilian cities such as Dresden or Hiroshima might also be considered war crimes. Others saw the tribunal as victor's justice, since only Axis leaders were prosecuted. Yet despite these controversies, the Nuremberg process represented an extraordinary leap forward in the codification of international criminal law. It established that aggression and genocide were punishable offenses under universal jurisdiction. By presenting evidence meticulously, documents signed by Hitler's inner circle, orders detailing deportations, letters about slave labor, and harrowing testimonies from survivors, the prosecution built an irrefutable case. Witnesses such as camp survivors, military officers, and bureaucrats described how ordinary administrative processes had been weaponized to commit extraordinary evil. The banality of paperwork became proof of mass murder. As days turned into months, the trial evolved into a moral mirror for the world. Newspapers published daily reports. People from liberated nations followed every word, hoping that justice would restore a sense of order after years of chaos. The Nuremberg courtroom, austere and disciplined, became a stage for humanity's confrontation with its darkest impulses.
As the proceedings unfolded, the Nuremberg Trials transformed from a mere legal exercise into a profound historical reckoning. The daily rhythm of the courtroom, opening statements, witness examinations, document readings, cross-examinations, was not only a display of legal procedure, but also an unfolding chronicle of how an entire state apparatus had turned ideology into systematic annihilation. The prosecution presented detailed documentation showing how ministries, corporations, and military units collaborated in the Nazi war machine. Records revealed the bureaucratic precision with which human lives were categorized, transported, and destroyed. The evidence extended far beyond Hitler's speeches. It demonstrated that genocide was not the product of a few fanatics, but of an entire structure sustained by ordinary administrators and professionals. One of the most haunting moments of the trial came when footage from the concentration camps was screened. The silent, grainy film showing piles of emaciated corpses and liberated prisoners reduced even hardened soldiers to tears. Goering himself looked away, visibly shaken. The footage left an indelible mark on the court. It was as if the ghosts of millions had entered the room. This was perhaps the first time in history that film evidence confronted a courtroom with the full reality of human suffering on such a scale.
The defense faced an almost impossible task. Their primary argument rested on the principle of nullum crimen sine lege, that no one should be punished for an act that was not a crime at the time it was committed. They argued that crimes against humanity had no precedent in international law, and that the defendants were merely obeying the laws and orders of their own government. Yet the prosecution countered that the acts were so inherently evil that no legal system could absolve them. As Robert Jackson stated, the real complaining party at your bar is civilization. Individual defendants tried to distance themselves from the most brutal policies. Ribbentrop claimed ignorance of the final solution, while Keitel insisted he had only followed orders. Rudolf Hess, who had flown to Scotland in 1941 in an attempt to negotiate peace, appeared mentally unstable during much of the trial. Albert Speer, Hitler's architect and Minister of Armaments, admitted moral responsibility but denied direct involvement in extermination policies. His admission was unusual among the accused and later influenced his relatively lighter sentence.
The trial also exposed the internal structure of the Nazi state. Through captured correspondence and testimony, it became clear that Hitler's dictatorship had operated through a mixture of ideological fanaticism and administrative efficiency. The machinery of death, Auschwitz, Treblinka, Sobibor, was not chaotic but meticulously organized. The defendants' signatures on deportation orders and supply lists turned abstract horror into concrete guilt. The prosecution introduced witnesses who had survived the concentration camps. Their testimonies were brief but devastating. They spoke of starvation, medical experiments, gas chambers, and the constant smell of burning flesh. One survivor of Auschwitz described seeing her entire family disappear within hours of arrival. The courtroom fell silent as translators repeated her words in 4 languages. For many, it was the first time such atrocities had been described publicly in exact, unflinching detail. Meanwhile, the judges faced the immense challenge of balancing moral outrage with judicial impartiality. They knew the world was watching, and their verdicts would shape the legitimacy of future international law. Lord Lawrence emphasized that the tribunal's purpose was not vengeance, but the establishment of principles that could prevent future wars of aggression.
Throughout the months of hearings, debates raged in academic circles and among politicians about the meaning of international justice. Was it possible to apply universal moral standards across nations with different legal traditions? Could individuals be held responsible for actions carried out under state authority? The Nuremberg judges answered yes, setting a precedent that continues to influence international criminal tribunals today, from The Hague to Rwanda. The logistics of the trial were equally complex. Every testimony had to be translated in real time into 4 languages – English, German, Russian, and French – by a team of interpreters working through headsets and microphones. This innovation, developed by IBM engineers, allowed for simultaneous interpretation and revolutionized multilingual proceedings around the world. Court reporters produced daily transcripts that ran into tens of thousands of pages. Journalists, historians, and observers from dozens of nations attended the sessions, transforming Nuremberg into a global focal point of moral reflection.
As weeks turned to months, the psychological tension in the courtroom deepened. Goering continued to behave as though he were still a Reichsmarshal, giving long speeches and mocking witnesses. However, his composure crumbled when confronted with direct evidence of extermination orders bearing his own signature. His attempt to justify the persecution of Jews as a necessary wartime measure was dismantled by the cold logic of documents and testimonies. Keitel, once the embodiment of Prussian obedience, broke down and admitted, "I was only obeying orders, but I see now that it was wrong." The Soviet prosecutor, Roman Rudenko, presented evidence of massacres committed in Eastern Europe, including the destruction of villages and execution of civilians. While the Western Allies focused primarily on crimes committed against occupied peoples, the Soviet delegation emphasized the immense suffering inflicted on their own population. Despite ideological differences, the four prosecuting nations maintained a remarkable degree of cooperation. By mid-1946, after months of testimony, the tribunal began hearing closing arguments. The prosecution urged the court to recognize the defendants not merely as political leaders, but as moral agents responsible for deliberate crimes. Jackson's closing statement summarized the essence of Nuremberg. The record on which we judge these defendants is the record on which history will judge us tomorrow. The defense, in turn, pleaded for clemency, portraying their clients as victims of circumstance, soldiers of duty, or men misled by Hitler's charisma.
Yet no defense could erase the mountains of evidence, the deportation lists, the orders for mass executions, the confessions, and the films. The tribunal adjourned in August 1946 to deliberate. On October 1, 1946, the verdicts were announced. 12 defendants were sentenced to death by hanging, 3 to life imprisonment, and others to various prison terms. 3 were acquitted. Goering, sentenced to death, committed suicide with cyanide the night before his execution. The sentences were carried out in the early hours of October 16, 1946, in the prison gymnasium adjacent to the courthouse. The hangings were witnessed by Allied officials and journalists. For many, the executions marked the symbolic end of Nazism. Yet the impact of Nuremberg extended far beyond retribution. It had established for the first time in history that leaders could be held personally accountable for crimes committed under state authority. The tribunal's legacy lay not only in its verdicts, but in its documentation. The trial produced an unparalleled historical record of the Nazi regime. The vast collection of evidence, transcripts, photographs, films, and witness testimonies became the foundation for Holocaust research and education. Moreover, the principles articulated at Nuremberg inspired subsequent international conventions, including the 1948 Universal Declaration of Human Rights and the Genocide Convention.
The closing days of the Nuremberg trials were a mix of solemnity, relief, and profound reflection. After months of exhaustive testimony and deliberation, the world had witnessed an unprecedented effort to translate moral outrage into a coherent legal framework. The final session of the tribunal was attended by journalists, diplomats, and survivors. The atmosphere in courtroom 600 was electric with expectation. When Lord Lawrence, the presiding judge, began to read the verdicts, a deep silence descended. One by one, the names of the defendants were called and their sentences pronounced. For each condemned man, the tribunal gave a brief but precise summary of the crimes proven beyond doubt. Hermann Göring, guilty on all counts, sentenced to death. Joachim von Ribbentrop, guilty, death. Wilhelm Keitel, guilty, death. Others, such as Karl Donitz and Albert Speer, were given prison terms. The court's tone was dispassionate, yet its authority reverberated around the world. The message was unmistakable. Power no longer guaranteed immunity. In the days that followed, reactions varied. Some Germans dismissed the trial as victor's justice, while others saw it as a necessary catharsis. Across Europe and beyond, ordinary people read the verdicts in newspapers and listened to them on the radio. The idea that even heads of state could be punished for crimes against humanity was revolutionary. It redefined sovereignty itself. Nuremberg, a city once synonymous with Nazi grandeur, had become a symbol of moral accountability.
The executions, carried out on October 16, 1946, closed a grim chapter in history.
Goering's suicide on the eve of his hanging was seen by many as his final act of defiance. The remaining condemned men met their fate quietly. Their bodies were cremated and the ashes scattered into the Isar River, a gesture meant to deny them any burial site that could become a shrine. Yet the true significance of Nuremberg lay not in their deaths, but in the principles the trial had established. The tribunal's final judgment articulated a vision of international law that transcended national boundaries. It declared that individuals have duties under international law which transcend the obligations of national allegiance. This principle became the cornerstone of later tribunals and conventions. It was codified in the Nuremberg Principles adopted by the United Nations in 1946, which defined crimes against peace, war crimes, and crimes against humanity as punishable offenses under international jurisdiction. In the years immediately following the trial, these principles began to shape global institutions. The Geneva Conventions of 1949 expanded protections for civilians and prisoners of war. The Universal Declaration of Human Rights in 1948 embodied the moral aspirations first voiced at Nuremberg. Legal scholars such as Hirsch Lauterpacht and Raphael Lemkin, whose concept of genocide had been implicitly affirmed during the proceedings, helped transform the moral shock of the war into enduring legal instruments.
Nuremberg also raised complex philosophical questions that continue to resonate. Could law truly express moral truth? Was it possible to punish evil without perpetuating vengeance? The judges sought to answer through balance, firmness without cruelty, justice without hatred. Their reasoning set a precedent for the rule of law, even when emotions ran deepest. The court did not attempt to judge a people, a culture, or a nation. It judged specific individuals whose deliberate acts had unleashed chaos upon the world. In this sense, Nuremberg was both symbolic and practical. It demonstrated that accountability is personal, not collective. However, the limitations of the tribunal were clear. Only the Axis powers faced prosecution. The crimes of Allied forces, strategic bombings, the Soviet massacre at Katyn, or the use of atomic weapons remained outside its jurisdiction. The victors had drawn the boundaries of justice. Yet despite these contradictions, the achievement of the tribunal lay in establishing a moral vocabulary that made future silence impossible. From that point on, the world had a legal language to describe the indescribable.
The Nuremberg archives became an enduring monument to truth. Historians and lawyers studied the transcripts to understand how bureaucracy could enable genocide. Psychologists analyzed the behavior of the defendants, seeking to uncover the mindset of obedience and ideological zeal. Hannah Arendt later called this phenomenon the banality of evil, the capacity of ordinary individuals to commit extraordinary crimes when moral judgment is suspended. This idea, born from the testimony of the Nuremberg defendants, profoundly changed how societies think about responsibility. The tribunal also influenced the way post-war Germany confronted its past. In the following decades, German educators, writers, and politicians would grapple with Vergangenheitsbewältigung, the struggle to come to terms with history. Nuremberg became a starting point for remembrance, a foundation for democratic rebirth. Its echo could be heard in later efforts to prosecute crimes in Rwanda, Yugoslavia, and beyond. When the International Criminal Court was established in 2002, its charter explicitly invoked the legacy of Nuremberg.
The idea that law could serve as a moral compass for humanity had taken root. For the first time, global justice was not an abstraction, but a living institution. Nuremberg proved that legal systems, when guided by conscience,
could confront even the most powerful perpetrators. It transformed the notion of justice from national retribution into universal principle. Yet Nuremberg was not the end of the story. It was the beginning of a global conversation about rights, dignity, and accountability. The images from the courtroom, the judges in black robes, the translators in glass booths, the defendants behind their rail, became icons of the 20th century. They reminded the world that civilization must defend itself not only with armies, but with laws.
By the time the tribunal closed in October 1946, it had sat for 218 days, heard 240 witnesses, reviewed thousands of documents, and produced a transcript exceeding 16,000 pages. Its proceedings were translated into multiple languages and distributed worldwide. Generations of jurists would cite its decisions as precedent. The courtroom itself, preserved today as a museum, stands as a testament to the triumph of reason over barbarism. The Nuremberg Trials were, above all, an assertion of faith that humanity, even after descending into darkness, could rebuild the foundations of moral order. They taught that justice must be seen to be done, that memory is a form of resistance, and that silence in the face of evil is complicity. Every subsequent tribunal, from Tokyo to The Hague, owes its existence to that belief. As the lights dimmed in courtroom 600 and the world moved on to rebuild, the echoes of those words, crimes against humanity, continued to resonate. They became part of the shared conscience of mankind. In a century scarred by war, Nuremberg offered not redemption, but direction, a path toward a world governed by law, not by power.
The conclusion of the Nuremberg Trials did not mark the end of the world's reckoning with wartime atrocities. Instead, it signaled the beginning of a broader experiment in international justice, an attempt to extend the principles established in Germany to the far reaches of a world scarred by conflict. Even as Europe began to rebuild, Asia was still haunted by the devastation of imperial ambition. Japan's surrender in August 1945 had ended a brutal conflict that stretched across the Pacific, Southeast Asia, and China, leaving behind millions of victims of invasion, forced labor, and massacre. Just as Nuremberg sought to bring the Nazi leadership to justice, the Allies turned their attention eastward to prosecute those responsible for Japan's aggression and its crimes against humanity. The International Military Tribunal for the Far East, IMTFE, commonly known as the Tokyo Trial, was established on January 19, 1946, under the authority of General Douglas MacArthur, Supreme Commander of the Allied Powers. Its mandate mirrored that of Nuremberg, to try those accused of planning and waging wars of aggression, committing war crimes, and perpetrating crimes against humanity. Yet the Tokyo Tribunal differed in scale, duration, and political complexity. While Nuremberg had 4 Allied judges, Tokyo had 11, representing nations that had fought in the Pacific War, including the United States, the United Kingdom, China, the Soviet Union, Australia, Canada, France, the Netherlands, India, New Zealand, and the Philippines.
The trial opened on May 3, 1946, in the War Ministry building in Tokyo. Before the judges sat 28 Japanese leaders, including former Prime Ministers Hideki Tojo, Koki Hirota, and Kuniaki Koiso, generals and admirals who had commanded Japan's armies and fleets, diplomats, industrialists, and ideologues. Emperor Hirohito himself was not indicted, a controversial decision influenced by American strategic interests in maintaining Japan's stability during occupation.
The exclusion of the emperor would remain one of the Tokyo Tribunal's most debated aspects, raising enduring questions about political pragmatism versus the ideal of universal justice. The proceedings were monumental in scope. Over 2 years, the prosecution presented more than 4,000 exhibits of evidence, called hundreds of witnesses, and submitted written affidavits detailing atrocities committed across Asia. The crimes included the Nanjing Massacre, where Japanese troops had killed an estimated 200,000 civilians in 1937, the mistreatment of prisoners of war along the Burma-Thailand Railway, where tens of thousands perished under forced labor, the systematic use of comfort women, and biological warfare experiments conducted by Unit 731 in China.
Chief Prosecutor Joseph B. Keenan of the United States opened the trial with words that echoed Jackson's speech at Nuremberg. "We are not here to wage vengeance, but to fulfill a solemn duty to humanity." The prosecution's central argument was that Japan's leaders had conspired to wage a war of aggression against their neighbors, violating treaties and basic principles of humanity. The defense, led by a team of Japanese and international lawyers, argued that Japan had been forced into war by Western imperialism and economic sanctions. They insisted that the concept of crimes against peace was a creation of the victors and that the trial applied laws retroactively. These debates reflected deeper philosophical tensions that had also shadowed Nuremberg. Could justice truly be impartial when administered by the victors? Could nations impose moral judgment on one another in the absence of a universally recognized legal authority? The structure of the Tokyo trial posed immense logistical challenges. Unlike Nuremberg, where 4 powers coordinated relatively smoothly, the 11-judge format led to frequent disagreements over procedure and interpretation. Cultural and linguistic barriers further complicated the process. Nonetheless, the tribunal persevered, relying heavily on interpreters and translators to ensure fairness. Each witness testimony was translated into multiple languages, a process that often slowed proceedings but also ensured inclusivity.
One of the most chilling aspects of the Tokyo trial was the presentation of evidence concerning biological warfare. Documents recovered from Unit 731 revealed how Japanese scientists, under the command of General Shiro Ishii, had conducted lethal experiments on Chinese civilians and prisoners, testing plague, anthrax, and other pathogens. The evidence shocked the world. Yet, not all perpetrators were held accountable. Some members of Unit 731 were granted immunity by the United States in exchange for their research data, a decision that has haunted the ethics of post-war justice ever since. The courtroom itself reflected the contradictions of the era. While the judges sat in solemn robes, the defendants, many still dignified former leaders, appeared behind glass enclosures, their faces expressionless. Hideki Tojo, the wartime prime minister, emerged as the most visible symbol of Japan's militarism. During cross-examination, he admitted political responsibility but denied personal involvement in atrocities, echoing the defenses heard in Nuremberg. Tojo's demeanor oscillated between defiance and fatalistic acceptance. In the end, he would be among those sentenced to death.
As the trial progressed, tensions between the Allied powers grew. The Soviet judge I.M. Zaryanov emphasized Japan's aggression against the USSR and China, while Western judges focused on crimes committed in Southeast Asia and the Pacific. The Indian judge Radha Binod Pal emerged as the tribunal's most controversial figure. In a 1,235-page dissenting opinion, Paul argued that the entire trial was illegitimate, an exercise in victor's justice that violated the principle of legality.
He contended that the concept of crimes against peace had no basis in existing international law, and that all participants in the war, including the Allied powers, bore moral responsibility for its outbreak. Though his dissent did not alter the verdicts, it became a landmark critique of post-war justice, cited decades later by scholars and politicians alike. On November 12, 1948, after more than 2.5 years of proceedings, the tribunal announced its verdicts. 7 defendants, including Tojo, were sentenced to death by hanging. 16 received life imprisonment. 2 were sentenced to lesser terms, and 2 died during the trial. One defendant was found unfit to stand trial due to mental illness. The sentences were carried out on December 23, 1948, at Sugamo Prison in Tokyo. Tojo, before his execution, expressed remorse and took full responsibility for Japan's actions, saying, "I am convinced that the sacred war of East Asia has ended in defeat. May the future generation learn from this."
Despite its limitations, the Tokyo Tribunal marked a critical step in the globalization of international criminal law. It extended the Nuremberg principles to the non-Western world, establishing that crimes against humanity and aggressive war were not confined to Europe. However, its legacy remained contested. In Japan, the trial was viewed by some as foreign-imposed justice, while others saw it as a necessary confrontation with the nation's militarist past. In the West, it was hailed as an affirmation that moral accountability must transcend geography and culture. The Tokyo trial also raised questions about selective justice. Just as the emperor had been spared, many industrial leaders who had profited from war escaped prosecution. The close relationship between Japan and the United States during the Cold War led to early releases for several convicted war criminals in the 1950s. These political decisions, while pragmatic, complicated the moral clarity that Nuremberg had sought to establish.
Yet the combined impact of the Nuremberg and Tokyo tribunals was profound. Together, they created a framework for future international criminal institutions. They demonstrated that global cooperation, despite political rivalry, could produce a shared vision of justice. The trials also generated an enormous archive of evidence, preserving the voices of victims and documenting the mechanisms of state-sponsored violence for future generations. The post-war tribunals in Germany and Japan laid the foundation for subsequent efforts to address atrocities elsewhere. In the decades that followed, the world would confront new horrors, genocides in Cambodia, Rwanda, and the Balkans. And each time, the spirit of Nuremberg and Tokyo would be invoked as both inspiration and challenge. The question that haunted the 20th century remained: could humanity truly learn from its past?
The post-war period after the Nuremberg and Tokyo trials was one of legal innovation and moral introspection. For the first time in human history, the world had collectively acknowledged that the atrocities of war could not be dismissed as the natural byproducts of conflict. They were crimes, acts for which individuals, not just nations, could and should be held accountable. Yet the question that followed was as complex as it was urgent: how to transform the exceptional justice of Nuremberg and Tokyo into a lasting system of accountability that could function even in times of peace. The newly created United Nations, founded in 1945 with the goal of preventing another world war, became the central platform for institutionalizing these ideals. The Nuremberg and Tokyo charters were studied by diplomats and jurists as templates for a future international legal order. In December 1946, the United Nations General Assembly unanimously affirmed the principles of the Nuremberg Charter and judgment.
These principles, codified later as the Nuremberg Principles by the International Law Commission, ILC, in 1950, established that individuals are responsible for crimes under international law, even when acting on behalf of the state. They also affirmed that obeying orders does not absolve one of responsibility, and that heads of state enjoy no immunity for crimes against humanity.
The codification of these principles was revolutionary. Before the war, sovereignty had been considered almost sacred. No external authority could judge the internal actions of a state. After Nuremberg, sovereignty was no longer absolute. It was conditional upon respect for fundamental human rights. This conceptual shift marked the birth of what we now call international criminal law. In the following years, the United Nations worked to translate moral outrage into tangible conventions. The Convention on the Prevention and Punishment of the Crime of Genocide was adopted in December 1948, thanks largely to the efforts of Polish Jewish lawyer Raphael Lemkin, who had coined the term genocide in 1944. Lemkin's idea that the destruction of entire groups was a distinct and punishable offense had found its moral validation in Nuremberg, though it was not explicitly included in the original tribunal charter. The Genocide Convention made it a legal obligation for states to prevent and punish such crimes, regardless of where they occurred.
That same year, the Universal Declaration of Human Rights, or UDHR, was adopted by the UN General Assembly. Drafted under the leadership of figures such as Eleanor Roosevelt, René Cassin, and Charles Malik, the Declaration enshrined universal rights, life, liberty, security, equality before the law, that had been systematically violated during the war. Though not a legally binding treaty, the UDHR became the moral and philosophical cornerstone for subsequent human rights law. Meanwhile, war crimes trials continued on a smaller scale across Europe and Asia. The Allied powers conducted hundreds of military tribunals under their occupation authorities. In Germany, the subsequent Nuremberg Trials, 1946 to 1949, prosecuted industrialists, doctors, and SS officers who had escaped the main trial. Among the most significant was the doctors' trial, which exposed Nazi medical experiments on prisoners and led to the Nuremberg Code, a set of ethical principles for human experimentation that continues to guide medical research today. The industrialist trials held companies like IG Farben, Krupp, and Flick accountable for their roles in producing weapons and using slave labor. These proceedings broadened the concept of culpability beyond political and military leaders to include economic and scientific elites who had profited from war and oppression.
In Japan, a series of additional tribunals were held in various territories liberated from Japanese occupation, such as the Batavia Trials in Indonesia, the Manila Trials in the Philippines, and proceedings in China, Burma, and Singapore. These trials dealt primarily with local war crimes, including massacres, forced labor, and abuse of prisoners. Though less publicized than Tokyo, they contributed to a growing body of international jurisprudence and demonstrated that justice could be pursued even outside the main Allied centers of power. Despite these successes, the momentum of post-war justice began to slow as the Cold War emerged. The ideological rivalry between the United States and the Soviet Union divided the world into opposing blocs, each reluctant to support international mechanisms that might later be used against them. Efforts to create a permanent international criminal court stalled in the 1950s due to political mistrust. The same superpowers that had championed Nuremberg now feared the implications of a truly independent global judiciary.
Nevertheless, the influence of Nuremberg and Tokyo persisted in the moral consciousness of the world. They had planted seeds that would eventually bear fruit decades later. In the interim, other mechanisms emerged. The European Convention on Human Rights, 1950, and the establishment of the European Court of Human Rights 1959 provided regional frameworks for protecting individuals from state abuses. Across the Atlantic, the Organization of American States adopted the American Declaration of the Rights and Duties of Man 1948, showing that the principles of Nuremberg had global resonance. The intellectual legacy of the tribunals also flourished in academia. Scholars such as Hans Kelsen, Hirsch Lauterpacht, and George Schwarzenberger analyzed the jurisprudence of Nuremberg and argued for a system of international criminal responsibility. Universities began offering courses on human rights law and international justice. The horrors of the Holocaust became a central moral reference point in political discourse, literature, and education. Films, documentaries, and memoirs brought the stories of the victims and the trials into the public consciousness, ensuring that the lessons of the past would not fade.
In the 1960s, renewed attention to war crimes emerged with the capture and trial of Adolf Eichmann, one of the chief architects of the Holocaust, who had fled to Argentina after the war. His abduction by Israeli agents and subsequent trial in Jerusalem in 1961 reignited global discussion about the meaning of justice and the legacy of Nuremberg. Eichmann's defense that he was merely following orders echoed the same arguments heard in 1945 and was once again rejected. The court sentenced him to death, reinforcing the principle that obedience does not excuse moral complicity. Hannah Arendt, covering the trial for The New Yorker, famously described Eichmann as the embodiment of the banality of evil, an idea that deepened public understanding of how ordinary people could commit extraordinary crimes. Eichmann's trial marked a bridge between the immediate post-war tribunals and the emerging human rights movement of the late 20th century. It demonstrated that international justice could still be pursued even after decades had passed, and that crimes against humanity carried no expiration date. Other cases followed: the prosecution of former Nazis in West Germany, the exposure of collaborators in Eastern Europe, and the moral reckoning that swept through post-colonial nations confronting their own histories of violence.
During these years, the idea of a permanent international criminal court never completely disappeared. Jurists and diplomats kept the discussion alive within the United Nations, drafting proposals and debating jurisdictional issues. Though Cold War politics prevented realization, the intellectual groundwork was being laid. When the Berlin Wall fell in 1989 and the ideological divide began to dissolve, the world once again turned its attention to the unfinished business of Nuremberg, to the promise of global justice that had remained unfulfilled for nearly half a century. By the 1990s, new conflicts in Yugoslavia and Rwanda would test that promise, reviving the spirit of Nuremberg in the form of modern international tribunals. But before those new institutions could emerge, the world had to remember why Nuremberg and Tokyo had mattered in the first place. They were not only about punishment, but about reaffirming humanity's belief in law, reason, and moral accountability. By the late 20th century, the echoes of Nuremberg and Tokyo still resonated in the halls of diplomacy and law schools across the globe. For many, the post-war tribunals represented both a triumph and an unfinished project. They had proven that international law could reach the highest echelons of power, but they had also revealed the limitations of justice when shaped by politics. The intervening decades saw new conflicts erupt, from Korea to Vietnam, from Algeria to Latin America, and in most of these, the mechanisms of accountability envisioned at Nuremberg were absent. Yet, the idea never truly died. Each generation returned to the principles of 1945 to 1948 as both a moral compass and a point of departure. As the Cold War drew to a close, the global community once again confronted the atrocities that demanded international response. The dissolution of Yugoslavia in the early 1990s brought horrific ethnic cleansing and mass killings to Europe's doorstep.
The world watched the siege of Sarajevo, the massacre at Srebrenica, and the systematic use of rape as a weapon of war. These crimes, broadcast on television for all to see, rekindled the urgent question: would humanity once again allow impunity to prevail? The answer came in 1993 when the United Nations Security Council established the International Criminal Tribunal for the former Yugoslavia, ICTY.
The ICTY, headquartered in The Hague, was the first international war crimes tribunal since Nuremberg and Tokyo. Its mandate was to prosecute individuals responsible for serious violations of international humanitarian law, including genocide, crimes against humanity, and war crimes committed in the Balkans since 1991. The tribunal's creation marked a decisive moment. It demonstrated that the spirit of Nuremberg could be revived even after decades of inaction. Over the next 2 decades, the ICTY indicted 161 individuals, including political leaders, military commanders, and paramilitary figures. Among the most prominent were Slobodan Milosevic, the former president of Serbia, and Radovan Karadzic, the leader of the Bosnian Serbs. Milosevic's indictment in 1999 was unprecedented. Never before had a sitting head of state been tried for war crimes by an international tribunal. Though he died in custody in 2006 before a verdict was reached, his prosecution symbolized a seismic shift in global norms, proof that even the most powerful were not beyond the reach of justice. The ICTY's jurisprudence refined many of the concepts introduced at Nuremberg, expanding definitions of crimes such as genocide and clarifying the doctrine of command responsibility. It also pioneered witness protection programs and established standards for fair trial procedures in international courts.
Just 1 year after the ICTY's creation, the world was once again shaken, this time by the genocide in Rwanda. In the span of 100 days in 1994, an estimated 800,000 Tutsi and moderate Hutu were murdered in a wave of orchestrated violence. The international community's failure to prevent the genocide prompted widespread soul-searching within the United Nations. In response, the Security Council created the International Criminal Tribunal for Rwanda, or ICTR, in November 1994. Based in Arusha, Tanzania, the ICTR built upon the legal and procedural foundations of Nuremberg, Tokyo, and the ICTY, but applied them within an African context. The ICTR's work was groundbreaking. It delivered the world's first international conviction for genocide and recognized rape as a form of genocide when used with the intent to destroy a group. It also held that media figures could be criminally liable for incitement to genocide, as in the famous case of the prosecutor versus Nahimana, Barayagwiza, and Nehez, where the tribunal convicted journalists who had used radio broadcasts to encourage mass killings. These judgments reflected an evolving understanding of accountability, showing that justice was not limited to those who wielded weapons, but extended to those who manipulated minds.
Together, the ICTY and ICTR reignited global momentum toward creating a permanent international criminal court, an idea first proposed in the aftermath of World War II, but long deferred by political divisions. After years of negotiation, that dream was finally realized with the adoption of the Rome Statute in 1998, establishing the International Criminal Court, or ICC. When the ICC entered into force in 2002, it represented the culmination of nearly 6 decades of struggle to transform Nuremberg's ad hoc justice into a standing institution of law. The ICC's mandate was ambitious: to prosecute individuals for genocide, crimes against humanity, war crimes, and the crime of aggression when national courts were unwilling or unable to act. Based in The Hague, It was designed not as a substitute for national systems, but as a court of last resort. Its creation was hailed as the final fulfillment of the promises made at Nuremberg, the dream of a permanent, impartial tribunal capable of enforcing international criminal law. Yet the ICC's journey has been fraught with challenges. Some major powers, including the United States, Russia, and China, have refused to ratify the Rome Statute, fearing that their own leaders or soldiers might become targets of politically motivated prosecutions. Critics have accused the court of bias, pointing out that many of its early cases focused on African nations. Supporters, however, argue that the ICC remains a vital mechanism for accountability in a world where impunity still reigns too often. Regardless of its imperfections, the ICC stands as a living descendant of the principles forged at Nuremberg and Tokyo, a testament to humanity's ongoing effort to bind power with law. The influence of these post-war tribunals extends beyond the courtroom. They have shaped how societies remember, reconcile, and rebuild after mass violence. Truth commissions, such as those in South Africa, Sierra Leone, and Colombia, draw upon the idea that confronting past atrocities is essential for genuine peace. Transitional justice, an entire field of practice and scholarship, emerged directly from the precedent set in 1945. The principles articulated then have informed national prosecutions in Argentina, Chile, Cambodia, and beyond.
Furthermore, the moral legacy of Nuremberg and Tokyo continues to resonate in contemporary debates about humanitarian intervention and the responsibility to protect R2P. When the world faced crises in Kosovo, Darfur, Libya, and Ukraine, policymakers and activists alike invoked the lessons of the post-war tribunals. The insistence that crimes against humanity must not go unpunished has become a defining feature of international political discourse, even when action lags behind rhetoric. Educationally and culturally, the Nuremberg and Tokyo trials reshaped collective memory. The Holocaust memorials, museums, and films that emerged in the post-war decades were not merely acts of remembrance, they were extensions of the same moral impulse that drove the prosecutors of 1945 to ensure that humanity never forgets. The meticulous documentation of evidence, the testimonies of survivors, and the reasoned judgments of the tribunals have become foundational texts in humanity's attempt to understand itself after catastrophe.
In the 21st century, as new technologies make the documentation of war crimes instantaneous through satellite imagery, social media, and digital archives, the principles of accountability laid down at Nuremberg and Tokyo have taken on renewed relevance. The idea that justice must be both global and individual remains one of the most enduring legacies of the Second World War. The tribunals proved that law could rise from the ashes of war, that reason could answer barbarism, and that even in the darkest chapters of human history, there could be a reckoning grounded not in vengeance, but in truth. As historians and jurists look back, they often describe the Nuremberg and Tokyo trials as both an ending and a beginning. They ended an era of unchecked impunity and began a new one where the moral and legal conscience of the world sought to restrain the abuse of power. They were imperfect, shaped by politics, and limited by their time, yet they stood as humanity's most ambitious experiment in justice. Every subsequent tribunal, every declaration of human rights, every attempt to hold tyrants accountable traces its lineage to those courtrooms in 1945 and 1946.
Ultimately, the post-war international tribunals taught the world that law is not merely an instrument of states, but a safeguard of humanity. They demonstrated that even in the aftermath of unimaginable destruction, civilization could reaffirm its belief in moral order.
The judges and prosecutors who sat in those chambers did not merely punish the guilty, they redefined justice itself. Their legacy endures, not only in the archives of history, but in the conscience of the world.
The story of the Nuremberg and Tokyo trials did not end with their final verdicts. Instead, those courtrooms ignited an enduring transformation in the global understanding of justice, morality, and human responsibility. The echoes of their proceedings have reverberated through every subsequent effort to confront war crimes and mass atrocities. From the early Cold War to the digital age, the legacy of post-war justice has evolved, adapted, and persisted, serving as a moral compass in times of political turbulence and ethical uncertainty. At its core, the Nuremberg experience demonstrated that the rule of law could survive even amid the ruins of civilization. When the Allied prosecutors stood before the judges in 1945, they were not merely punishing individuals, they were redefining civilization itself. They proclaimed that the deliberate extermination of millions, the enslavement of populations, and the waging of aggressive war were not simply violations of treaties, but crimes against humanity as a whole. This was a revolutionary idea, one that placed the individual, rather than the state, at the center of international legal responsibility. It redefined sovereignty and reshaped moral philosophy.
Over time, the Nuremberg and Tokyo principles have been woven into the very fabric of international law. The concept of crimes against humanity, introduced in 1945, evolved into a cornerstone of global jurisprudence. It became the basis for prosecutions in later tribunals, from Rwanda to Yugoslavia, and was codified in the Rome Statute of the International Criminal Court. Likewise, the prohibition of aggressive war laid the groundwork for modern debates about humanitarian intervention, preemptive defense, and the limits of state power. But beyond law, the post-war tribunals left a deeper, more philosophical legacy: the belief that justice is a universal moral duty. The prosecutors at Nuremberg often invoked the idea of civilization versus barbarism. In their view, civilization depended not on material progress or military victory, but on adherence to moral law. The trials were an affirmation that humanity could still choose law over revenge, order over chaos, and truth over denial. In this sense, the Nuremberg and Tokyo trials were not merely legal proceedings, they were moral performances on the stage of history, setting a precedent for generations to come.
One of the most enduring lessons of these tribunals was the rejection of the superior orders defense. Defendants like Hermann Göring and Hideki Tojo claimed that they had acted under orders from higher authorities, arguing that obedience to the state absolved them of personal guilt. The tribunals rejected this argument decisively, asserting that moral choice remains possible even within hierarchical systems. This principle has since become a cornerstone of military ethics and human rights law, reflected in the codes of conduct of armies around the world and in the United Nations declarations on human rights. Another profound legacy of the post-war tribunals lies in their approach to evidence, documentation, and historical record. The meticulous collection of documents, witness testimonies, and visual materials at Nuremberg and Tokyo created a permanent archive of truth. These records have become invaluable historical resources, shaping how we understand the Second World War and its atrocities. They have also served as a defense against denialism and revisionism. The words spoken in those courtrooms, the testimonies of survivors, the confessions of perpetrators, stand as a collective memory of humanity's darkest hour.
In the decades that followed, the idea of justice expanded beyond war crimes. The Universal Declaration of Human Rights, the Geneva Conventions, and the Genocide Convention
all carried the moral DNA of Nuremberg. The notion that individuals possess inalienable rights, regardless of nationality or circumstance, owes much to the intellectual revolution sparked by those tribunals. Even the modern movement for civil rights and decolonization drew inspiration from the universalist language born in 1945. Leaders in Asia, Africa, and Latin America invoked the same principles to challenge imperialism and racial discrimination, arguing that justice must apply equally to all peoples, not just to the defeated. Culturally, the post-war tribunals transformed how societies remember and narrate mass violence. Before Nuremberg, victors often wrote history as a story of triumph. After Nuremberg, history became a space for moral reckoning. The trial transcripts, films, and photographs from those proceedings reshaped collective memory, influencing art, literature, and cinema. Filmmakers such as Stanley Kramer in Judgment at Nuremberg, 1961, and documentarians like Alain Resnais in Night and Fog, 1956, used the moral language of the tribunals to explore guilt, complicity, and the fragility of human conscience. The very phrase, "crimes against humanity," entered popular consciousness as a synonym for ultimate evil.
Yet the legacy of these tribunals is not without contradictions. They have been criticized for representing victor's justice, a selective application of moral law that punished some while excusing others. At Nuremberg, Allied bombings of civilian targets were never prosecuted. At Tokyo, the atomic bombings of Hiroshima and Nagasaki were not addressed. Such omissions reveal the political limits of the time. But even within these flaws lies an important truth. The post-war tribunals were not perfect expressions of justice, they were the first steps toward it. They established a model that later generations could improve upon. The late 20th century saw renewed interest in these legacies as nations confronted their own pasts. In Germany, the process of Vergangenheitsbewältigung, coming to terms with the past, was deeply influenced by the spirit of Nuremberg. The German education system incorporated Holocaust studies, memorials were built, and public discourse embraced accountability as a civic duty. In Japan, however, remembrance was more conflicted. The Tokyo trials perceived foreign bias, and the exclusion of the emperor from prosecution led to decades of debate over national guilt. While some Japanese intellectuals and politicians called for repentance, others sought to revise or minimize the country's wartime culpability. These differing national memories illustrate how justice and history can diverge even when grounded in the same events.
In a broader sense, the Nuremberg and Tokyo trials redefined the relationship between law and morality in the modern world. They demonstrated that law must not only codify norms but embody values, that legality without morality is hollow. Philosophers such as Karl Jaspers, Hannah Arendt, and Jacques Maritain grappled with the meaning of guilt, responsibility, and evil in the aftermath of the trials. Jaspers introduced the concept of metaphysical guilt, suggesting that entire societies bear responsibility for allowing evil to flourish. Arendt's analysis of Eichmann's tile later expanded this idea, showing that ordinary individuals, through complacency or obedience, can perpetuate monstrous crimes. These reflections turned Nuremberg into not just a legal milestone, but a moral and existential one. As the world entered the 21st century, new challenges tested these legacies. The wars in Iraq, Afghanistan, and Syria, the genocides in Darfur and Myanmar, and the atrocities in Ukraine and Gaza all raised questions about the effectiveness of international justice. Despite the existence of the International Criminal Court, prosecutions remained slow and uneven. Political realities continued to shape who faced justice and who escaped it. Yet the moral framework established at Nuremberg endured as a benchmark. Even when justice faltered, the very language of human rights, war crimes, and crimes against humanity reminded the world that certain acts could never be normalized. As the 21st century unfolded, the ideals born from the ashes of World War II faced both extraordinary affirmation and profound challenge. The establishment of the International Criminal Court, ICC, in 2002 marked the formal institutionalization of Nuremberg's legacy, yet it also revealed the deep tensions between law and geopolitics that had always haunted international justice. The ICC's first cases focused largely on African conflicts, such as those in Uganda, the Democratic Republic of Congo, and Sudan, demonstrated the court's commitment to confronting impunity. Figures such as Thomas Lubanga Diallo, convicted for the conscription of child soldiers, and Omar al-Bashir, indicted for genocide in Darfur, symbolized the court's willingness to target even sitting heads of state. However, these same cases exposed the fragility of the system. Critics accused the ICC of disproportionately targeting Africa, while failing to address crimes committed by powerful Western nations. The refusal of the United States, Russia, China, and several other major powers to ratify the Rome Statute underscored a familiar paradox. Those most capable of enforcing global justice were often the least willing to be bound by it. The resulting asymmetry led some scholars to argue that the ICC risked repeating the same victor's justice dynamic that had plagued Nuremberg and Tokyo.
Despite these criticisms, the court continued to develop a rich body of jurisprudence. Its rulings on gender-based violence, the destruction of cultural heritage, and the recruitment of child soldiers expanded the scope of international criminal law beyond traditional wartime offenses. The conviction of Ahmad al-Faqi al-Mahdi in 2016 for the destruction of historical monuments in Timbuktu was groundbreaking. It marked the first time the ICC prosecuted cultural destruction as a war crime. In doing so, the court reaffirmed that justice was not only about punishing those who kill, but also about defending the moral and cultural fabric of humanity. At the same time, other international and hybrid tribunals continued to draw upon the Nuremberg precedent. The Special Court for Sierra Leone, established in 2002, prosecuted those responsible for atrocities during the country's brutal civil war. It made history by convicting Charles Taylor, the former president of Liberia, for aiding and abetting war crimes and crimes against humanity, a direct echo of the accountability principles first articulated in 1945. The extraordinary chambers in the courts of Cambodia, the ECCC, sought justice for the crimes of the Khmer Rouge regime, while the Special Tribunal for Lebanon and the Kosovo Specialist Chambers reflected a continuing effort to adapt international justice to new contexts. Beyond the courtroom, the legacy of the post-war tribunals profoundly influenced the global human rights movement. Organizations such as Amnesty International, Human Rights Watch, and the International Commission of Jurists adopted Nuremberg's moral language in their advocacy, insisting that the protection of human dignity was a universal responsibility. The rise of global media and the Internet enabled ordinary citizens to witness atrocities in real time, generating public pressure for intervention and accountability. This shift marked a democratization of moral concern, a world in which outrage could cross borders faster than armies. However, the globalization of justice also created new dilemmas. As states invoked humanitarian rhetoric to justify military interventions, the line between justice and power grew blurred. The 1999 NATO bombing of Yugoslavia, the 2003 invasion of Iraq, and later interventions in Libya and Syria were all defended, at least in part, as efforts to prevent crimes against humanity. Yet critics argued that such actions often violated the very principles of sovereignty and legality that Nuremberg had enshrined. The debate over whether international law served as a shield for the weak or a tool of the strong became one of the defining questions of the modern era.
Despite these tensions, the intellectual legacy of Nuremberg and Tokyo remained resilient.
Universities around the world continued to teach their lessons, and generations of lawyers, diplomats, and activists drew inspiration from them. The notion that there can be no peace without justice became a central tenet of post-conflict reconstruction strategies. Truth and reconciliation commissions, modeled loosely on the Nuremberg idea of moral accountability, appeared in South Africa after apartheid, in Latin America after military dictatorships, and in Eastern Europe after communism. These bodies did not always deliver punishment, but they sought something equally vital: acknowledgement, remembrance, and moral healing. The integration of international criminal law into domestic legal systems was another manifestation of this enduring influence. Countries such as Germany, Canada, and Argentina enacted legislation allowing national courts to prosecute crimes against humanity committed anywhere in the world under the principle of universal jurisdiction. This principle, which originated in the post-war tribunal's assertion of universal moral responsibility, allowed for the arrest and prosecution of figures such as Augusto Pinochet of Chile. His arrest in London in 1998 under a Spanish extradition request sent shockwaves through the international community. Though he was never ultimately tried, the case established a precedent that former heads of state could no longer assume immunity from justice once they left power.
Cultural and educational initiatives further reinforced these legal developments. Museums, memorials, and archives dedicated to the Holocaust, the atomic bombings, and wartime atrocities proliferated throughout the world. They served as reminders that justice was not only a matter of courts, but also of collective memory. The very existence of these institutions testified to Nuremberg's enduring lesson that forgetting is the first step toward repetition. The survivors who had testified in 1945 became educators, their stories carried forward by new generations through books, films, and digital media. In the realm of philosophy and ethics, thinkers continued to grapple with the meaning of evil and responsibility in light of the tribunal's lessons. The concept of crimes against humanity evolved from a legal category into a moral metaphor for the limits of human cruelty. Theologians debated whether justice could ever be truly restorative after mass murder. Philosophers questioned whether legal systems could adequately address the depths of human suffering. Yet, amid these debates, one conclusion remained consistent. Nuremberg and Tokyo had changed the moral vocabulary of civilization. They had made it impossible to discuss politics, war, or morality without invoking the language of human rights and accountability.
The post-war tribunals also influenced international relations and the very structure of global governance. The United Nations, though often paralyzed by political divisions, continued to act as a custodian of the Nuremberg principles. The creation of the Responsibility to Protect R2P doctrine in 2005 represented a significant evolution of those ideals. R2P asserted that sovereignty was not a privilege but a responsibility, that states which failed to protect their populations from genocide, war crimes, and ethnic cleansing forfeited their claim to non-interference. Though its implementation has been controversial, R2P embodies the same moral impulse that motivated the prosecutors at Nuremberg: the belief that the international community cannot remain silent in the face of mass atrocity. At the same time, the digital age introduced new dimensions to the pursuit of justice. Crimes could now be documented by satellites, smartphones, and social media posts in real time. Investigators began using open-source intelligence (OSINT) to gather evidence from conflict zones inaccessible to traditional investigators. NGOs and journalists collaborated with legal experts to preserve this digital evidence for future prosecutions.
The democratization of information gave victims new tools to make their voices heard, but also raised new questions about privacy, verification, and the politics of representation.
By the mid-2010s, international justice stood at a crossroads. On one hand, the architecture of accountability built since 1945 had never been more sophisticated. On the other, the rise of authoritarianism, nationalism, and disinformation threatened to erode the moral consensus that had sustained it. Leaders accused of war crimes used propaganda to discredit international courts, while some powerful states withdrew their cooperation entirely. Yet even in this climate of cynicism, the memory of Nuremberg and Tokyo remained a potent moral symbol. The simple assertion that crimes against humanity exist, that some acts are so evil they offend the entire human species, continued to resonate, inspiring activists, journalists, and ordinary citizens around the world. As survivors of the Second World War grew fewer, the responsibility for preserving their legacy passed to institutions, educators, and storytellers. The lessons of Nuremberg and Tokyo were no longer about punishing specific individuals, but about sustaining a global moral imagination. An understanding that justice is a continuous process, not a single event. In this sense, the post-war tribunals were less an end to the horrors of the 20th century than a foundation upon which the 21st could build its ideals.
The enduring power of the Nuremberg and Tokyo trials lies not only in their historical significance, but also in their continuing ability to provoke reflection on the meaning of justice, power, and humanity itself. As the decades passed, their lessons evolved beyond the specific horrors of the Second World War to address the broader, timeless question: can law restrain human cruelty? This question continues to define the moral landscape of our time, shaping debates on war, peace, and responsibility across the globe. In the modern era, international justice has expanded into a complex ecosystem of courts, commissions, and advocacy networks. The legacy of the post-war tribunals is evident not only in institutions like the International Criminal Court, but also in local and regional mechanisms that seek to balance punishment with reconciliation. In Rwanda, the Gacaca courts drew on traditional community-based justice systems to process the aftermath of genocide. In Colombia, the Special Jurisdiction for Peace was established as part of the peace process with the FARC guerrillas, incorporating both restorative and retributive elements. These efforts illustrate how the spirit of Nuremberg has been adapted to different cultural and political contexts, proving that the pursuit of justice is not a single model, but a living dialogue between memory and morality.
At the same time, the concept of justice itself has evolved. While Nuremberg emphasized accountability for leaders and commanders, contemporary debates increasingly focus on systemic and structural forms of violence: economic exploitation, environmental destruction, and digital repression. The notion of ecocide, for instance, has emerged as a potential fifth category of international crime, reflecting the growing recognition that mass harm to the environment may one day be treated as a crime against humanity. Similarly, calls for accountability for cyber warfare and disinformation campaigns reveal how technology has transformed the battlefield, and with it, the nature of moral responsibility. These developments extend the moral logic of Nuremberg into new frontiers. If the post-war tribunals established that individuals can be held responsible for crimes committed in the name of the state, the 21st century suggests that corporations, algorithms, and even artificial intelligence systems may one day face scrutiny under similar principles. The ethical foundations laid in 1945 thus remain relevant in an age of unprecedented complexity, where power is diffuse, borders are porous, and the consequences of human action are global. Education and collective memory have become central to sustaining this legacy. Across continents, schools, museums, and digital archives preserve the testimonies of those who lived through war and genocide. Virtual reality projects allow new generations to walk through reconstructed trial chambers and concentration camps, creating an immersive moral education that transcends time and geography. These initiatives serve not only as remembrance, but as prevention. By confronting the past honestly, societies fortify themselves against future atrocities. Yet memory alone is not enough. As history has shown, remembrance without vigilance can devolve into ritual. The challenge of our time is not merely to remember Nuremberg as an event, but to live by its principles. This means confronting injustice even when it is politically inconvenient, acknowledging suffering even when it implicates one's own nation, and upholding truth even when lies are easier to believe. In this sense, the real tribunal is not in The Hague or Tokyo, but in the conscience of humanity itself. The trials also left an indelible mark on moral philosophy and the psychology of evil. The work of Hannah Arendt, particularly her analysis of the Eichmann trial, expanded on Nuremberg's insights by revealing how ordinary individuals become instruments of atrocity through obedience and conformity. Her concept of the banality of evil captured the unsettling truth that monstrous acts often arise not from sadistic impulses, but from thoughtless submission to authority. This understanding has profoundly influenced ethics, education, and even leadership studies, reminding societies that justice requires not only institutions, but also moral courage at the individual level. Similarly, the reflections of Karl Jaspers, Telford Taylor, and Simone Weil offered deeper insights into collective guilt and the moral responsibilities of nations. Jaspers argued that moral guilt extended beyond the perpetrators to all who tolerated or ignored injustice. Taylor, one of the American prosecutors at Nuremberg, later criticized his own government's failings in Vietnam, insisting that the principles of Nuremberg must apply universally or not at all. These voices remind us that justice, to be meaningful, must transcend political expediency.
The symbolism of the Nuremberg courtroom itself has become a universal icon. Its wooden benches, translation booths, and the image of the defendants sitting beneath the gaze of justice have been reproduced countless times in textbooks, documentaries, and films. They represent the moment when humanity, after descending into barbarism, tried to reassert moral order. Each generation that revisits those images faces the same question: are we still worthy of that moral inheritance? As the 21st century progresses, new crises test the endurance of that inheritance. The Russian invasion of Ukraine in 2022, for example, has revived the vocabulary of Nuremberg in political and legal discourse. International lawyers have called for special tribunals to prosecute crimes of aggression, echoing the post-war precedent. Likewise, the documentation of atrocities against civilians has invoked the same logic that guided the Allied prosecutors 80 years earlier, that truth must be recorded and accountability must follow. Similar discussions surround other global conflicts in Gaza, Sudan, Myanmar, and elsewhere, where the tension between realpolitik and moral principle remains unresolved.
Globalization and digital interconnectedness have also altered how justice is perceived.
The rise of citizen journalism and real-time evidence collection means that no atrocity can easily be hidden. Yet it also means that misinformation can spread with equal speed. The challenge of distinguishing truth from propaganda is one that the Nuremberg prosecutors never faced on such a scale. Today's digital battlefield demands a new kind of vigilance, one rooted in critical thinking, transparency, and a commitment to factual integrity. The same moral foundation that guided Nuremberg must now be applied to the virtual arenas where reputations, narratives, and even realities are contested. Another profound evolution in the legacy of Nuremberg lies in its relationship with reconciliation. While the original trials were punitive by design, subsequent generations have recognized that justice must also heal. This insight underpins the work of truth commissions in South Africa, Chile, and Canada, where acknowledgement of harm and apology have often proved more transformative than punishment alone. The post-war experience taught humanity that justice without empathy can become hollow, just as mercy without accountability can become meaningless. The balance between the two remains one of the great moral challenges of our time. Looking to the future, the lessons of the post-war tribunals offer guidance not only for international law, but for the broader human project. They remind us that civilization is fragile, that progress is not guaranteed, and that the capacity for evil exists within ordinary human beings. They also affirm that moral progress, however imperfect, is possible, that truth can be spoken, justice can be sought, and humanity can still aspire to decency after catastrophe. The Nuremberg and Tokyo trials demonstrated that history need not be a cycle of revenge. It can be a movement toward accountability, reflection, and renewal. The ultimate legacy of these trials is the idea of universal human responsibility. This idea transcends borders, ideologies, and generations. It insists that no government, army, or ideology is above moral scrutiny, that power must answer to principle, that the crimes of one era can serve as lessons for the next. In a world increasingly fragmented by nationalism, polarization, and misinformation, this universalism stands as both a challenge and a hope. To honor the spirit of Nuremberg and Tokyo, societies must not only preserve their memory, but continue their mission to defend truth, uphold justice, and protect human dignity wherever it is threatened. The tribunals of 1945 and 1946 were not the end of a story, but the beginning of an unfinished journey. Every generation must decide anew whether to continue that journey or abandon it. If there is one enduring message that resonates across the decades, it is this: justice is not the triumph of the strong over the weak, but the recognition of our shared humanity. It is the belief that even in the aftermath of horror, law and conscience can still speak with authority. The Nuremberg and Tokyo trials showed that humanity, even at its lowest point, could still rise to a firm moral order. Their verdicts echo not only through courtrooms, but through classrooms, parliaments, and the quiet moral decisions of individuals. In the final analysis, the story of the post-war tribunals is not simply a legal narrative, it is a testament to hope. It is the story of how humanity, faced with the abyss, chose to build a bridge of justice across it. That bridge remains fragile, weathered by time and politics, yet it still stands. And as long as it stands, so too does the possibility of a world governed not by fear or vengeance, but by reason, law, and the unyielding conviction that justice, however imperfect, is the truest expression of our shared humanity.